Do you have advice that you would like to share with us concerning proper disclosure of odometer readings on vehicles that are more than 10 years old?
So the common myth with vehicles that are beyond 10 years old is the odometer statement or the mileage doesn't matter. And I'm here to tell you it does. And we've convicted folks of spinning odometers of vehicles that are 15, 20 years of age or older, or even older. Today, average vehicle on the road, 11, 12 years old, vehicles retain their value significantly from what they did years ago. The odometer has a huge part of that. And just because the federal odometer law says, 10 years and newer for disclosure, Iowa state law still says that you cannot alter, you cannot change anything to do with the odometer. It doesn't list any age on the vehicle at all. So if you have a collector's vehicle that's 50 years old, there's no exemption in the law that says that the odometer on that vehicle doesn't matter. When you advertise vehicles for sale and you put mileage in there, there's a process in place if there's something wrong with the odometer, as far as if you replace it, having it reset to what it was, having tags put in the door jamb. There's a process for that. But any advertising, any discussion about the mileage, you've got to be up front with them as far as what you know about the odometer. The excuse that, well, the odometer isn't working properly, that doesn't work because the law says it has to be. And a dealer really, right, wrong, or indifferent, a dealer's held at a little higher level of accountability when it comes to odometers, because dealers that sell vehicles, that's what they do, that's the business they're in. So for a dealer to say, I just didn't really know the odometer wasn't working properly, I can tell you in front of a judge or jury they're not going to buy that, because that's the business dealers are in. The general public, there may be a little leeway, but even then, the general public has no right to be changing or tampering with an odometer on a vehicle. So very clearly, as far as a dealer disclosing it, I highly recommend that any purchase agreement, any statement that they're writing and giving to the buyer as a bill of sale, that there's some notation made about the mileage. I mean, to document that of what it is, regardless of what's required in the title or not. But it's good business practice for a dealer to make a note of what that mileage was, so the dealer has a record of it, because something may not come up for 3 years or 5 years down the road, and a dealer might get questioned, well, why you own this vehicle, what was the mileage? Well, there again, the vehicle was 12 years old when I had it, I didn't care about the mileage. That doesn't work. It's still, that's still a significant part of the vehicle and of the history of the vehicle, and most importantly, the value of the vehicle. And to protect the dealer, it's in their best interest to record what that mileage is, to make sure that the new buyer understands what that mileage is, and that if there's a problem with the odometer, that the dealer's aware of it, they get it repaired and fixed properly and disclosed properly prior to putting that vehicle for sale, ideally, so that way any prospective buyer is not misled by an advertisement that may be out there or any discussions that may occur during the transaction, that it's very clearly known by the buyer as far as what the mileage is, and that that as far as the dealer knows, any knowledge they have is the odometer works properly and this is the mileage that's on the vehicle.